It is my honor and pleasure to be the chair of today's session for this important issue. As many governments recognize their limitation in dealing with surging immigration, the role of migration agents is becoming more and more important. The government expects the migration agents not only to assist the immigrants, but take up a bigger role as the extended arms of governments in transnational management of global human resource. Some even say that the migration agents are designing the immigration itself. Having said that, unless regulated or quality controlled, they can also lead us into chaos, letting unwanted people sneaking into the country, and therefore the immigration administration might be in trouble. So as a result, countries like Australia, Canada, and United Kingdom have regulated the migration industry and have been successfully running the system. So in this session, we have invited the heads of the regulatory bodies of those countries to hear about their experiences and achievement in general and also specifically global human resource management. So I'll start with Mr. John Ryan. He is the chairman of Canadian Society of Immigration Consultants. Mr. Ryan worked for the Canadian government as a senior immigration officer, and in recognition of his public and charitable service to Canada, Mr. Ryan was granted knighthood by the Sovereign Order of St. John of Jerusalem and conferred the grant of arms by the Governor General of Canada. Thank you very much, Mr. Ryan.
Good morning. I always hate being the first speaker. I was nominated for the privilege this morning to speak to you. So for the next 15 or so minutes, I'm going to try and not put you to sleep, and I'm going to try and paint a picture for you of some of the challenges we face in Canada within our immigration or migration program, working with agents, and also ensuring that the consumer, the immigrant, is given the best possible treatment when they choose to immigrate to our country. Distinguished hosts and guests, my colleagues, ladies and gentlemen, I'm honored to be here today at the Global Human Resources Forum, and I wish to thank our hosts for the opportunity to speak to you today. I'm extremely proud to be here in your beautiful country of Korea, and I congratulate heartily on what I've seen so far as to be a first-rate, world-class conference that you've organized. But to my topic. Canada faces some very unique human resources challenges in years to come, and some of them are similar to what Korea faces in terms of an aging demographic. In fact, recent census data in our country shows that by 2030, the only growth in the Canadian population will come from immigration. So think about that. We have the second largest country by land mass in the world. We have a population of 32 million people, and yet, because of our aging demographics, we're going to be facing an issue where immigrants are going to represent the growth of the Canadian economy for the future. That means supporting our social welfare programs, such as our health care, our pensions, etc. So a global workforce is extremely important to Canada to have access to. It's about attracting qualified immigrants as much as it is about retaining qualified immigrants. It's not just good enough to attract them to come into your country. You have to provide mechanisms and support mechanisms to ensure that they stay and contribute to the country. This is a challenge I think Korea is also facing. The Canadian population is getting older and human resources are becoming scarcer. Already we're experiencing acute shortages in trades, professions, and even in our services sector. So today I'll speak to you about the contribution that certified Canadian immigration consultants make in meeting those challenges and the contribution that they make to a strong Canadian immigration system. Let me start with a few facts. Every year, approximately 270,000 immigrants come to Canada to settle. Let me give you some perspective on that. So you see if I can get this video going. There we go. 270,000 immigrants doesn't sound like much, but when you have 32 million as your population, that means in Canada we're attracting 1% of our population a year. This has huge implications for us as a society because it means we have to provide infrastructure, we have to provide policies such as our multicultural policy, which welcomes people to Canada from all over the world. If you go to my home city in Toronto and you stand on any corner, you will see faces from every corner of the world. There, as immigrants, proud with their own heritage and also bringing their own heritage to contribute to Canadian heritage. In Canada, we embrace multiculturalism. Just to give you some ideas, 270,000. China, 41% of our immigration a year comes from mainland China. 11.6% comes from India. 7% comes from the Philippines. 5.2% comes from Pakistan. And 3.2% comes from Korea. Korea is actually our top 5 country, in the top 5 source countries for immigrants who are coming both to immigrate permanently, to open businesses, as well as to contribute as temporary workers. Immigrants from South Korea contribute to every sector of the Canadian economy and form a very valuable part of our cultural identity. Most importantly, they provide a social and economic link, very valuable, between our two countries. To settle in Canada, more than 50% of those immigrants are represented by paid counsel. In other words, immigration consultants, Canadian lawyers, and Canadian notaries. 50%. These lawyers, consultants, and notaries help these immigrants navigate our immigration system and help the immigrants meet all the requirements of entry into our country. And can you imagine moving to a new country, different language, different culture, different legal system as an immigrant, and having to understand that legal system, having to have a place in that legal system, have standing, and then successfully get what you're trying to do in terms of immigrating and being part of that system. And it doesn't matter, it's an international problem we all share in terms of how do we facilitate workers, international labor, human resources moving from country to country easily without having to deal with very complex legal issues. And I think you'll find that over the course of time, as immigrants become more and more important to the global economy, this is going to become a catchphrase in how do we harmonize our immigration systems to help the ease of movement of international capital, human capital. By law, paid counsel in Canada must be a certified member of my organization, CSIC, or they have to be a Canadian lawyer, a member of provincial or territorial bar association, or a member of the Chambre de Notaires de Quebec, which is an organization in the province of Quebec. I will tell you a little bit more about my organization and how it came to be and the role it plays in a few minutes. Firstly, I'd like to explain to you just how important third-party agents and consultants are to the movement, the global movement of human capital. As I mentioned, one of the forces and the problems facing Canada in the next years ahead is that the census data shows by 2030, our population growth will be solely dependent on immigration. We're already starting to feel the effects of this trend. For example, the province of Alberta, in the western part of Canada, our main economic engine in terms of the energy sector, is experiencing record growth right now, and its manpower needs are growing, following suit, growing exponentially. Certified immigration consultants play a very important role in attracting more and more qualified, skilled immigrants to fill those human resource needs. It's a partnership between government, the private sector, and the non-government public sector in order to produce an immigration program which attracts skilled immigrants, people who have contributions to make from all over the world. Governments alone don't have the resources. It has to be a joint effort of these various parts of our economies. They work to help identify qualified, skilled people to fill specific labor market needs. And they also bring business expertise and capital to Canada, which is also extremely important, especially in our burgeoning manufacturing and resource-based economy. They assist those individuals in navigating the Canadian immigration system, and once they have arrived in Canada, the immigration consultants, third-party agents handle all the paperwork, and many provide help to the immigrant with settlement and integration to the new immigrant into the Canadian system. Of course, there are a number of government agencies involved in immigration in Canada, the most notable of which are the Departments of Citizenship and Immigration Canada, which is our federal immigration department, our Human Resources and Development Canada, which is our federal labor ministry, for lack of a better word, the Immigration Refugee Board, which is involved in asylum claims, refugee claims, the determination of those, and the Canada Border Services Agency, which is tasked with securing our borders and in many respects reinforcing the enforcement provisions under the Immigration Refugee Protection Act. Many clients do not understand the differences, and this is one of our problems, between a lawyer, an immigration consultant, a governmental or a non-governmental organization. Most immigrants do not have the sophistication to understand the difference and how each of these bodies can help. They may be unfamiliar with Canada's official languages and immigration laws. Even completing application forms in another language can be an intimidating task for many. Certified immigration consultants work with and on behalf of their clients to assist them in successfully completing what can be a complicated process. Although through our society, certified consultants continue to assist in the development of an immigration system. How? Well, as certified consultants, we work regularly with government, helping them tune and fine-tune immigration policies, changing if necessary, in order to better refine our laws and policies in order to facilitate the attraction of the international capital, human capital that we need so much in Canada. We work with the governments to help further development government policies and programs for many reasons, the most important being that we have come a long way as a regulator, and it is only a short period of time. Our Canadian regulatory body has only been around for 4 years. So we're 5 years young this year. There's been many lessons we've learned along the way, and of course, we want to see progress and we want to continue to contribute to what is a very, very important part of our national interest. What has been the Canadian regulatory system? Well, prior to 2004, we had no such standards for competent practice of immigration consultants. There were no such standards for levels of education, knowledge, experience required to offer one's service as an immigration consultant. Worse, however, there was absolutely no protection for the immigrants themselves who were seeking counsel on immigration matters if things went wrong. So if they received bad advice, if they were taken advantage of, if they were given wrong information, they had no recourse. This, as you can imagine, paved the way for constant abuse by immigration agents at the expense of the immigrant and the refugee communities who wanted to make Canada their home. And I would suggest that if Korea is thinking about regulating its immigration advice industry, that it needs to do so in a way that recognizes the potential or the contribution that immigration agents provide in terms of attracting capital while balancing measures and laws to ensure quality control and protection for the consumer so that people will function within the system in a way that assists immigrants rather than preys upon them. Moreover, in Canada, our experience is the sad reality with unscrupulous consultants were and who are indeed practicing, are presenting themselves as experts on immigration matters despite the fact that they have little or no training or expertise. The Canadian Society of Immigration Consultants came into existence because of a unique partnership between the immigration consulting community, the Canadian government, immigration stakeholders, and the consumers themselves of immigration services. All of these parties recognize the importance and urgency of offering consumers some protection from fraudulent con artists. The Government of Canada in 2004 amended the Immigration and Refugee Protection Act in order to recognize or designate authorized representatives. From that point on, it was required that you be a member of the Canadian Society of Immigration Consultants, a lawyer or a notary. CSIC was created, and this is very unique, we were created entirely independent of government as a self-regulating body for immigration consultants. That means immigration consultants regulate immigration consultants. Our mandate is to protect the consumers of immigration consulting services and to ensure the competent and professional conduct of our members. And we refer it to as protection through regulation. We maintain a fair and judicious and enforceable set of regulations. We set standards, manage accreditation process, and provide mandatory continuing professional development to all of our certified immigration consultants. Just as an example of what the Society has accomplished to date in 4 short years, we've developed a comprehensive code of professional conduct. We've developed an effective complaint, discipline, and hearing mechanism. We've developed advertising rules which tell an immigration member or an immigration consultant how they have to appear and what they can say and what they can't say in their advertising. We've introduced liability insurance in favor of the consumer for errors and omissions that the consultant would make, similar to Canadian lawyers. So if a consultant does something wrong or doesn't adequately represent the immigrant's interests, there is a recourse that can be taken against an insurance policy, in addition to the member being subject to our disciplinary proceedings. We've also introduced a compensation fund, and this is a recent development. It's not just good enough to have insurance for errors and omissions. You need to have a compensation fund that compensates the immigrant for the criminal actions of a member. No insurance company compensates for criminality, but as a regulator, you need to provide this. A mandatory continuing professional education development, and a very effective testing and accreditation process. I want to underscore to you the importance of an effective accreditation process. Our process is a competency-based process, and it's based upon a consultant being trained, educated, and demonstrating competency and good character. In addition, the person has to develop a proficiency in one of Canada's 2 official languages. And let me just stop here. A proficiency is not just being able to understand and speak the language, but you have to be able to understand, read, and write the language to an extent where you understand complex laws and you can adequately represent your client in front of the tribunals. In Canada, our members appear in front of tribunals where the very life of individuals, immigrants, is potentially at stake. So we have set a very high English and French language standard for our consultants. Once someone becomes a member of CSIC, they are held accountable to our rules and our professional conduct. They are also continued to take advantage of professional development opportunities that we offer. Everything that we have accomplished since 2004 has improved the industry immensely in Canada, and above all else has increased consumer protection, particularly for those who are most vulnerable to potential abuse and exploitation. We just had a recent case of 24 Korean truck drivers who immigrated to Canada, where there was a lot of media attention, where they were taken advantage by an immigration consultant who was subsequently found guilty of misconduct. Just last week, those Korean truck drivers were compensated as a result of the regulatory body in Canada. So it works. So you can see our organization represents Canada's newest profession. And as Canada relies more and more on immigration to increase our population and meet our labor market needs, it is a profession that is both growing in number and in importance. Just to give you an idea, we have 1,419 certified members currently now. 284 were approved this year alone. Doesn't sound like much, but it is. And 680 are currently studying in the 6 university and colleges programs that we have running coast to coast in Canada to become immigration consultants. That all sounds great, but don't get me wrong, there have been very significant challenges that we've faced in the last 4 years. Not all consultants welcome CSIC and the new regulated environment. In fact, we've had quite a lot of resistance to the reality of regulation. We certainly have our detractors. The creation of CSIC has redesigned the professional landscape for immigration advisors in Canada. It's a whole new ballgame. Inevitably, that has meant stepping on some toes in the process, putting some people out of business who were in business prior to the regulation. However, the consumer is now the better for it. Some individuals and groups do not welcome the coming of higher standards and stricter rules. There have been a number of court challenges to our authority to regulate, some of which are still in progress, but this was expected in our planning stages, and so far we have won every challenge to our authority, and we will continue to do so. Another one of the greatest challenges at the moment for CSIC is something we call ghost agencies or ghost consulting, rogue immigration consultants who are not complying with the regulation. And that's not rogue immigration consultants just in Canada, it's overseas as well. Our system provides for extraterritorial application of Canadian law. So irrespective of where the CSIC member is, Canadian law applies for them anywhere in the world. We believe that ghost agents or ghost consultants, their very existence is damaging the credibility of the profession. And most importantly, is a serious risk to the immigrants themselves who have no guarantee of quality, no recourse, and not a shred of protection from unscrupulous and unsupervised practices. Because ghost agents are not certified immigration consultants in our organization, they fall outside of our jurisdiction. However, they are not above the law in Canada, and we are working with our government to develop new and better ways to root them out as they seek to circumvent the law and to abuse unsuspecting clients. Since 2004, stiff penalties have existed in Canadian legislation to deflect the misuse of authority and trust. However, to be effective, these penalties need, and the government needs to commit to enforcing the laws on a vigorous basis. For example, according to the Immigration Refugee Protection Act, that's the Canadian Act, an immigration consultant who acts without the authorization of CSIC can be subject to a fine of $50,000 Canadian dollars and receive a jail term of up to 2 years or both. So it's pretty serious. Moreover, unsuspecting consumers who are caught dealing with ghost agents, willfully or not, could see their applications delayed for up to 2 years or even outright rejected. So this is very serious business. We are working with our government partners to eliminate ghost agents because they have the potential to tarnish the reputation of the profession and shake the confidence of our clients, stakeholders, governments, and general public place within the services that we offer as a regulator. Our legislation, as I've just mentioned, affords us global jurisdiction, and that certainly plays in our favor when it comes to tracking down ghost agents. Canadian embassies across the world can apply our legislation to extend consumer protection. This principle of extraterritorial is fundamental to our a model of regulation. In fact, our society has made a point of reaching out, as we're doing today to you, beyond our borders to work with other national regulators of immigration professionals. We have already established excellent working relationships with Suzanne, the Commissioner of the Office of Immigration Services Commission in the UK. I keep getting, that's a big mouthful, that is. And with the Migration Agent Registration Authority in Australia, who Arnold's going to be speaking to you about a little later. We continue to have rich, insightful discussions with these organizations and others, sharing best practices and advancing common issues and interests. And we take every opportunity at CSIC to reach out to world leaders and organizations such as yours around the globe who are coming together to meet human resource, economic, and the social challenges posed by immigration and migration. That is why, in my wrap-up comments, I'm so pleased to be with you here today to describe the changing Canadian context and how we, Canadian certified immigration consultants, are making such a large contribution to the movement of human capital. Of course, these challenges are not confined to Canada. Immigration issues are by definition international in nature, and I know many of you here today are from countries that share similar challenges. I'm confident that all of you share our concerns about protecting our nationals, our immigrants, and you share our concerns about how to put unscrupulous operators where they belong, and that's out of business. So for all of these reasons, I will conclude by saying that I am most open and interested in discussing these issues further with any of you. And I would just like to thank you again for inviting us and giving us the opportunity to speak to you at this exceptional conference. Thank you.
Thank you, Mr. Ryan, for demonstrating that the migration agents operate beyond national jurisdiction where the governments could not reach. Next speaker is from Australia, Mr. Armel Konya. He is the immediate past president of Migration Agents Registration Authority, and he has been really very crucial in Australian MARA operation. So he's going to show us the actual relationship between migration agents and global human resource induction. Thank you.
Commissioner Chukuyoho and Professor Park, colleagues, as with Canada, Australia is a multicultural society, and sitting at the airport about to leave for Korea the other day, I was reading a speech given by Rupert Murdoch, who may be familiar to some of you. It was a keynote address talking about the future economy of Australia in these troubled times, and one of the comments that he made, he said, "I have no concerns about immigration to Australia." He said, when persons stop being interested or cease to become interested in migrating to Australia, that is when my concerns do arise. As I said, we are a multicultural society, and we in fact have a sizable Korean influence in Australia. And within a few hundred meters of my particular office, we are able to get bibimbap and kalbitang and udon, and more importantly, soju as well, which at lunchtime is actually very useful to get through the day. But let me turn to the purpose of why I'm here. I'll start by giving a brief overview of the migration advice profession in Australia, because it is my task here today to give you a little bit of background about regulation in Australia, some understanding of how the employer-related visas work, and that will give you some understanding then of how RMAs, registered migration agents, and HR, human resources, work together, because we are virtually fused in this particular area of practice. Migration agents in Australia have been regulated since 1992 with the establishment of a regulatory body then known as the Migration Agents Review Board. The relevant legislation required all persons providing migration assistance, whether or not they were practicing lawyers, to become registered as migration agents. I emphasize that because lawyers such as myself were part of a group which challenged the legislation in the court, and unfortunately we lost in the High Court back in 1994. The MARB, the MARB, was operated by the Department of Immigration. Now, in order to open the profession to as many non-lawyers as possible, the then minister set very low entry standards, and in doing so created repercussions which are still being felt today. Substantial numbers of persons with vastly differing professional abilities became migration agents, the good, the bad, and the very, very ugly. Ever since then, the regulatory body has been saddled with the task of raising standards whilst simultaneously weeding out the unscrupulous. In the interim, of course, the profession has become tainted by the actions of a few. So, Commissioner, and all of those here who may be working to establish a regulatory system in Korea, please set your standards high to begin with, not later. It is very difficult to turn back the clock. Once the genie is out of the bottle, that is it. In 1998, the legislation was overhauled. The MARB, M-A-R-B, was dissolved, and in its place the Migration Agents Registration Authority, the MARA, which I'll refer to from time to time, of which I was, until recently, was the chairman. At the same time, the Migration Institute of Australia, which was and is the peak body for migration agents, its professional organisation, was appointed to act as the MARA. So we wear two hats. We have a board meeting on one day as the MIA, and the next day we meet as the MARA. At that stage, back in 1998, the MIA had only 300 members. The structure remains in place today and is regulated by means of a deed of arrangement between the MIA and DIAC, which is the Department of Immigration and Citizenship. In June 1998, MARA was established. It employed only 5 staff members. At the time, there were 2,500 agents. Today, the MARA employs 26 persons, and there are some 3,800 agents. The Act, that's the migration legislation, requires that any person who gives immigration assistance as defined be registered as a migration agent. The legislation, it's important to note that the legislation distinguishes immigration assistance from immigration legal assistance, and therefore lawyers who are not registered are entitled to represent clients in certain appellate federal jurisdictions. As one would expect, there are substantial criminal sanctions imposed on those who are convicted of unregistered practice. It must be noted that the MARA has no jurisdiction over unregistered agents, and it falls to DIAC, unfortunately, to take action, which it seldom does, against such persons. I say that with respect, of course. Perhaps not. In order to become registered as a migration agent in Australia, one must either be a lawyer, such as myself, with a current legal practicing certificate, or one must pass the prescribed entry qualification. At present, the entry qualification is a graduate certificate approved by the MARA, which is currently being offered by 4 universities. I expect that the graduate certificate be replaced by a graduate diploma in the near future. It has always been my ambition to raise that standard even further, and when I was on the board, I was driving it to a degree level, and it's going to be hopefully achievable in years to come, where one will need to qualify by means of a degree, and once you get there, of course, there will be little to distinguish non-legal agents from legal RMAs. But that is for the future. High standards of English are now in place, which we have, in relation to which we have followed the Canadian system. We didn't always have that. And it is something that I'm particularly pressed for after having been invited to a conference in Canada some 2 years ago. It's about time we got re-invited. But we'll leave that aside for the moment. It is also a requirement of the Act that applicants be fit and proper persons. Professor, please let me know if I'm rambling on, and I'll... 10 more minutes, right? No, I'll stick to the schedule. And registration must be renewed annually, and one is required to demonstrate that during the previous year one has received 10 points for CPD, compulsory or continuing professional development, which is something that we in the MIA insisted upon the government didn't want to impose that because they believed that it would restrict people entering the profession, would you believe. So once again, Commissioner and others who may be looking at the system, impose these requirements in the beginning, not later. And of course there's a code of conduct which regulates the conduct of migration agents. The Act stipulates that only an RMA is entitled to charge fees for rendering migration assistance. In fact, if one fails to produce a contract and charges a fee, even if you are an RMA at a later stage, in most circumstances, the client is entitled to seek reimbursement of those fees, which of course does cause some excitement. Now, the Act empowers the MARA to deal with complaints against RMAs from clients or from other sources, including the department itself, and sometimes from the tribunals or the federal courts. And from a sanctioning perspective, the MARA is entitled to either caution an agent, suspend an agent subject to certain conditions, or in fact, in the worst cases, deregister an agent. Is in fact even entitled to deal with agents who are no longer registered. We've managed to close a loophole there. Now, turning now to the connection between RMAs and the migration industry and human resources. Where does this fit in? Let me sketch at this stage very briefly what our relevant visa system is all about. Bearing in mind that some 70% of employer-sponsored visa applications, both permanent and temporary, are lodged by RMAs, 70%. Employed-sponsored visas are really divided into two types. There's the temporary and the permanent. Of the temporary visa, the most commonly and most important used is what is called the subclass 457 visa, technically known as the subclass long-stay business visa, but I'll refer to it as the 457 visa. It is a visa permitting the holder and his or her family to live and work in Australia for up to at least 4 years. The visa application consists of three parts. There's a sponsorship by a prospective employer and nomination, describing the position to be filled by the employee, and of course the application for the visa itself. Now these visas are usually lodged, these applications are usually lodged together, and in fact we as agents lodge them online. We have a certain procedure where it's all done electronically. If each of the requirement is not met, or any of the requirements is not met, the entire visa application will fail. However, on the other hand, if a full application is lodged, the application could be determined within a matter of days, sometimes in certain circumstances overnight. Imagine that, what that means to an employer corporation, to have an employee being able to start on a Monday and you lodge the application the week beforehand. In certain circumstances, 457 visa applications may be made whilst the visa applicant is in fact present in Australia, unlike the States. Therefore, we often deal in matters where prospective employees, where the prospective employee has entered the country on a short-stay business visa or a tourist visa even, and then applies for and is granted a 457 visa. The 457 is not the only temporary work visas. There are others. There's only one important class of permanent employer-related visa that I will deal with, and that is called ENS, the Employer Nomination Scheme visa. At first glance, there are in fact some similarities between the two categories. There is the sponsorship application, a nomination, and the application for the visa itself. However, there are some very important differences. So then, coming to the essence of what I'm here to talk about. How do the RMAs interact with human resources in the above visa environment? The answer is that interaction occurs at almost every stage. It is for human resources, of course, to identify a need, that is, that one or more employees having appropriate skill sets are needed by an employer, usually immediately, in fact usually yesterday, or within a 2-year period, and that persons with those qualifications are just nowhere to be found in Australia. It is the task of the RMA to advise HR as to whether or not the goals of the employer are in fact achievable, and to assist HR to meet the corporation's goals. An issue which often presents itself at the outset, of course, is timing, where the employee is needed, as I said, yesterday. The agent will alert human resources to the possibilities and the pitfalls of bringing out an employee on a short stay visa, which is allowable, which are in many cases obtainable via a travel agent, or in fact even on the net, and thereafter applying onshore for the 457 visa. But as I said, there are pitfalls which need to be understood. Then, of course, there is the issue of quantum. An approved 457 sponsorship is valid for 2 years, and multiple nominations may be sought, 50, 60, 100, as much as the employer wishes within certain circumstances. The number of approvals will depend on the circumstances of each application and may require negotiation with the department. The agent and HR management closely collaborate to plan for the future needs of the employer. Is the employer likely to qualify as a sponsor if it's the requirement of the 457, the B457 regulations, that the sponsor be lawfully trading in Australia? Is this requirement met? If not, then could the sponsor qualify as an overseas sponsor? That is also allowed by the regulations. It is not uncommon for the RMA to be closely involved in the establishment of a new corporation in Australia. This will involve the transfer of the spearhead employees who are to establish the business in Australia, so you understand that we are involved at every single stage, even before the business enters Australia. In this regard, RMA's ability to understand business plans becomes essential. There are occasions when the RMA provides input into the plan and assists HR and the company to assess whether in fact that plan is feasible to begin with. If a sponsor is one of a web of associated companies, and we've all come across that, which may result in an employee being sponsored by one company, being paid by another company, and perhaps performing work in Australia for a third company, then the RMA is to advise on issues as to whether or not the relevant corporations are what are known as, quote, related corporations, according to the corporations legislation, which will impact on the company's ability to act, to be approved as a sponsor. The RMA must be able to read and understand the employer's financial statements and to assess the company's training programs in certain circumstances. The advisor is required to work with HR to structure an acceptable training program. So we are involved even at that stage. It is an essential obligation of the RMA when acting in 457 matters to fully explain to HR the meaning of what are called undertakings. These are guarantees provided by a sponsor automatically when the sponsor signs the sponsorship form. There are a list of undertakings provided, contractual warranties provided to the department. By providing these undertakings, the sponsor assumes a substantial financial risk, which is often not appreciated by the company. These undertakings, for example, these undertakings include the underwriting of certain medical costs for the employee and his or her entire family. So the whole issue of medical insurance arises. Also included is warranty that the employer will adhere to state and federal industrial laws. Now, this is very important. It is my experience that human resource professionals located both inside but usually outside Australia do not fully appreciate the fact that the contract of employment between the sponsor and the employee is subject to the federal and state laws of Australia, no matter how senior the employee may be, and whether or not the contract is stated to be subject to the laws of a foreign jurisdiction. Please note that. Therefore, as a lawyer and registered migration agent, I'm called upon from time to time to advise managers on employment contracts. Recently, I worked closely with human resources from a multinational corporation which wished to sponsor a number of employees to be employed by subsidiary corporations in which each employee owned a share. The structure bore resemblance to a franchise operation, and I was required, in fact, to restructure the deal in order to ensure that it met the immigration requirements, but nonetheless did not defeat the intent of the parties. The 457 nomination process also calls for collaboration between human resources Only occupations specified in a gazetted list of occupations, which are amended from time to time, may be nominated. Of course, the drafting of position descriptions are important in this regard. The structuring of salary packages is a topic often discussed between the RMA and HR. The regulations are very specific as to the calculation of minimum salary levels, MSLs, and if not appreciated by human resources may lead to the cancellation of the employer's sponsorship, which could prove to be financially damaging, of course, for the employer. Whilst agents are not tax advisors, we do alert HR to tax-related matters, such as living away from home allowances, which apply in Australia, and tax benefits available to temporary residents. And so we come to the 457 visa application itself. The primary issue here is this: does the prospective employee have the qualifications and skills needed to fill the nominated position? Is HR aware of the fact that certain nominated positions will require an employee to prove that he or she has certain proficiency in English? The agent will raise any concerns in this regard, hopefully with HR. HR must be made aware of the fact that 457 applications by employees sourced from certain countries will take substantially longer to process and will lead to additional character and reference checking. I do not include career in this particular regard. Then we come to an interesting dilemma for the agent. When lodging the 457 visa application, really the agent acts for both of the employer and the employee. The information supplied to by the employee and his or her family to the agent sometimes discloses character and medical information which the employee has not disclosed to HR. Such information could delay an application or even cause it to fail. Unless an agent has been specifically approved in advance by the employee to disclose such information, then the agent is duty-bound not to disclose it. I do recall very briefly in this regard as acting in an employer nomination matter once, and the particular employee was going to be employed as a senior manager, very senior, in fact, managing director of a large corporation. And shortly before the visa was to issue, the gentleman phoned me from abroad in a very distressed state, and he said, I have to confess that I have a criminal conviction, but I haven't disclosed it. Well, how long were you in jail? I said, no, I was fined. Well, how much? He said, well, $50. I said, well, $50 is not even a parking offence. What was it? After discussing some time, he confessed that he had, how shall I say, entered into a contract with a certain professional lady who was standing outside his car in a laneway one night, and he was, the contract was unfortunately broken by the arrival of certain law enforcement people. I said, but that's not a problem. It happened years ago. He says, but you don't understand. My wife doesn't know. That had a sequel some years later, in fact last year. This all happened about 15 years ago. And I was consulted, in fact, by this gentleman's son who wished to marry a young lady from outside Australia. And they came to see me about obtaining what is called a spouse visa, and I said to myself, I know what your daddy did, and you don't know about that. But one has to have fun when acting as an agent now and then. Now, the liaison between the agent and HR does not end on the grant of visa. The department monitors all sponsors on a regular basis, and the agent is often engaged to ensure that the responses of the department meet all requirements. In conclusion, and I am concluding, I'll refer very briefly to the employer nomination procedure. Employer nominations procedures for permanent residents also draws HR migration expertise together in much the same fashion as I've already, to which I've already referred. There are certain nuances which are different. For example, the requirement of a 3-year employment contract, and for the unwary, the employer could find itself saddled with having to pay out substantial damages to an employee if the contract is terminated in the event that the contract in fact has not been properly drafted in the first place. But in conclusion, I must say that human resource professionals and the RMA is an inseparable team operating in an area of very great importance to Australia. And not only to Australia from a social point of view, but to its economic growth. Thank you.
Thank you, Mr. Konya, for pinpointing how indispensable migration agents are to achieve government's goals. We are running very late, so before I would like to present our last speaker from the United Kingdom, and we only have 15 minutes, regretfully. Commissioner Susan McCarthy is the Commissioner of the Office of Immigration Service Commissioners. Ms. McCarthy held a number of senior public sector positions before she entered the office, including private secretaries of 2 Home Secretaries, and she also lectured at University of Manchester and also was a solicitor. Welcome, Mr. McCarthy.
Yes, thank you. Thank you for inviting me, Professor Park, and I'm very pleased to be here today. There are advantages of being the final speaker because you can sort of summarize what you've heard from the others. And what I would say to you, first of all, is that we are all facing the same issue, which is the global movement of people. I know we've talked about human capital, human resources, but I like to think about the people who go to immigration agents as individuals, all with their own problems and stories. And if you talk about them as capital and resources, you lose, I think, that particular dimension. The other point that I would pick up from the 2 previous speakers is that every country has to handle this particular issue in its own way, in accordance with its own historical background, its political and economic systems, its constitutional relationships. You will hear about a third model which approaches the same problem, which is regulating immigration advisors. But we do it differently from what you've heard from Canada and from Australia. The other point I'd like to make is that what we have here is sort of a chicken and egg question. When do you actually decide to bring in a regulatory scheme? Do you do that after you have a body of people that you recognize are competent to be able to do this work? Or do you say, no, we will in fact create the regulatory body, and by doing so create a means by which you can in fact create that profession of immigration advisor distinct from someone who is actually qualified to give legal advice over a whole range of issues, such as I am and Arnold is, but is not actually a specific specialist necessarily in immigration law. So that is the chicken and egg question, and I'm going to talk a little bit about that as well. But I'd like to start off with a basic question. Why should any country put in a system to regulate immigration agents? Why should you do it? Not every country has it. There are about 4 countries that have it at the moment. 3 of them are here today. New Zealand is another one. There are other countries that are thinking seriously about it, including, I believe, Korea. But it's not absolute that every country must have this. So why should you do it? And I think there are 2 reasons for that. One is that bad immigration advice actually ruins lives. It ruins the lives usually of people who need that advice and of their families and others. But on top of that, and equal to that, is the fact that if you do not regulate immigration advice, it is the government itself which suffers in terms of possible abuses of the system. So I see my role as the commissioner, and there is only one commissioner at the Immigration Services Commissioner Office, as being a protector of the government's immigration system so that it is not actually exposed to abuse. And to me that is quite as important as protecting the client. I should say that that is the chicken and egg question and the main question of why you should do it. Prior to 1999, in the UK, there was no regulation of immigration advisors. It came in because there became a pressure where we had this perceived view that the country was being overrun by asylum seekers who were then going to take over housing benefits, the infrastructure, the jobs, whatever you might say. And I would suppose that in Korea, like in lots of other countries, there is that same perception. People are coming in. What do you do? How do you control them? How do you make sure they're the right people? And that is a legitimate question, which has to be addressed. In the UK, how it was addressed is that the Labour Party, in 1997, in its Labour Party manifesto, said it was going to bring in an office to regulate immigration advisors. And basically, it did that by creating the Office of the Immigration Services Commissioner. And when they did that, there were two types of immigration advisors out there already. There were the ones that were not for profit, people who did not charge clients because they were charities or they were bodies, they were voluntary and community bodies, and they were readily recognized and readily identifiable by the government because often the government funded them. So when the office opened its doors, most of the groups that came in and became regulated by us were the not-for-profits because we knew where they were and they all wanted to be in the scheme. The ones that have taken time for us to get in, A, because they have to know that we exist, and B, then they have to think about whether they want to apply, and C, we have to push them. Either they jump and they don't do immigration advice anymore, or they stay and work with us, were the for-profits. And after something like 8 years, there are now more for-profit organizations in my organization being regulated than there are not-for-profits. So we have slowly changed the dynamics as such. Now, I hope I can do this. Let's find out. Whoops, there we go. Yes, I always am surprised when I can do anything technical. This is the main thing, which is since 2001, if you want to give immigration advice within the UK, you've got to be regulated by my office, or you've got to be regulated by a professional body over which I have oversight, or you've got to be exempted by ministerial order, like an employer giving advice directly to an employee. If you don't fall under that, you commit a criminal offense. And I do go after people. I was just told by John, am I going to talk about my 10 police officers? And I will, because they're lovely. I have a whole group of very nice ex-policemen, and they go out on the beat, they find the illegal advisors, they tell them either you stop or you come into the scheme. Many of them come into the scheme. The ones that don't, usually taking money, often given to them by charitable organizations, from people who don't understand and are scared of the system, and we take them to court. We take them to the criminal court, we prosecute. I had a case just a month ago, a man who styled himself as the professor. Hello? All right, can you hear me now? I have a good loud voice. You have to in my profession. Basically, the professor has been giving immigration advice illegally. He was caught, and he's not a professor of any university you've ever heard of, or neither have I, and he's now spending Christmas inside at Her Majesty's pleasure, as we've put it. We've had a recent case of another person who's gone inside as well for 6 months. It's quite common. We've had about 75 prosecutions in the last 8 years, virtually all of them successful. So the point is, if you don't abide by us, you in fact get done. So we have sanctions. Now let's see whether we go from there. Oh, this is the one with the card. I love this. It always makes me sound like I'm, Lewis Hamilton at a speed racing. This is the most important thing about my job. I am there to make sure that those that give immigration advice or services, that is, I tell you how to do it, or I fill out the form, or I stand up in a tribunal on your behalf, If I do any of those things, I have to be fit and competent. A well-meaning, not-for-profit organization that keeps its files in a box in the corner is not going to be fit and competent. They may be well-meaning, but they're not going to do their clients a good job. They're just as troublesome as someone who is deviously taking money off people and not filing at all. This is another way in which we are a different body from the ones you've just heard. I am what's called a non-departmental public body, but I am totally independent of government, and I am totally independent of being an immigration advisor. Both Arnold and John are immigration advisors. I have never been an immigration advisor. I don't want to be an immigration advisor. My role is to be a regulator of immigration advisors. I therefore have no conflict. There is no trade association that is combined with my association, with my government body. There are trade associations, there are two of them. They are there to represent their members. I am there to regulate those who wish to be an immigration advisor, whether they're a member of a trade association or not. And in my mind, that is the better approach, because I think otherwise you have a conflict of interest. I am also directly accountable to the Home Secretary. I am not accountable to UKBA. I am not accountable to the UK Border Agency or to the Home Office as such. I'm appointed by the Minister. I'm accountable to the Minister. I'm accountable through her to Parliament. That is, to me, the right way to do something like this. I do three things basically. Essentially, I'm a regulator. I, as I say, go out and restrict and control illegal activities, and I try to raise best practice within the community of immigration advisors. And therefore I regulate. Obviously, I'm an ombudsman as well. I get complaints. I get about 500 complaints a year. They are not meant to put the person back in the position they would be in if they hadn't suffered the loss. I do not run a compensation scheme. Somebody takes my order, they can go to a civil court and they can use that order in order to get compensation or to get their documents back if that's what they want. They sometimes may use my order to go back to the Home Office and argue that they should in fact have their decision overchanged and be allowed into the country. I do require all of my advisors to have professional indemnity insurance, which is similar to what you have in Canada. But my role as an ombudsman is to use my determinations of those complaints to regulate better. Because the idea is that if I'm getting a lot of complaints against a particular company, and I can accept complaints about anyone, regulated or unregulated, or regulated by the Law Society, it doesn't matter. But I can use those complaints to deal with them if they're inside my scheme, or deal with them if they're outside my scheme. And I have to say we do take, and this is something I would recommend, we have a rolling program of asking complainants what they thought of the process of complaining. And they tell us the reason they complained was in order to stop other people getting advice from this bad advisor. That is what's motivating them to come out of the shadows, to be very brave and courageous, and come to us and ask us to look into the problem they've had. I'm not going to talk about these, but just to say that we have our framework documents. We regulate by using written information, intelligence, premises audits, competence assessments, and we also require CPD, which we do with the Open University, who we work with as a partner in our continuing professional development. We've talked about this already. And this is just to show you our profession. I should say that I have a staff of 70 people. We regulate some 4,000, directly regulate some 4,000 individual advisors and some 2,000 organizations, all across the UK. Immigration is not a devolved matter in the UK. It is not for Scotland, Wales, and Northern Ireland and England to do different things. Immigration is a UK-wide phenomenon, so I regulate all across the United Kingdom. Now this is one slide I would like to take a second on. I think that's the end of it. No, there's one more. This is the impact that we have had on the UK immigration advice sector. Before I came on the scene, you couldn't go to the phone book and look up immigration advisor because it wasn't recognized as a profession, as a type of supplier that you could go and find. You might find solicitors, but you wouldn't find the term immigration advisor. You do now, because the OISC created that profession and identified it and gave it a form and a robustness that is important to it, and an integrity and a respect that they require. And then these are the other things that I looked at and said, well, what have we done? Well, we've set a minimum standard of requirement, we've increased the professionalism, we keep people informed about where they can find fit and competent advisors, we have a complaint scheme, we helped set up the trade body, one of them, and we made sure that people were aware of where they could get good advice by getting the OIC logo for advisors who were within the scheme. And finally, on to the future. Importantly is the points-based system. Some of you may know about this. If you want to come into the UK as an employee from the end of this month or as a student from next year, you have to go through the new points-based system. And most of that work is done outside of the UK's borders. And that means that I'm going to have to work with my colleagues over there in creating probably a global network of recognized advisors. And it would be wonderful if when Korea, and I hope it's when, not if, has its own regulatory scheme, that it joins with us in working up such an accreditation so that if you have an advisor here and it meets the minimum of standards that we require and vice versa, there is mutual recognition. Also, they're reviewing us and there'll be new legislation, I understand, to be giving us new powers to extend what we can do in the new year. And finally, bad immigration advice ruined lives. Good immigration advice is in everyone's interest. I think going back to what I started with, which is people. Those who come to an immigration advisor in my country are often the most vulnerable of people. Often they don't speak English very well. Often they are afraid of authority. And it is very, very important that they get the best service possible. And that's what my office tries to do. Thank you.
Thank you, Commissioner, for showing us typical British organization. It was really helpful. Now, having shared valuable experiences with the top personnel of overseas regulatory bodies, the head of the Korea Immigration Service of the Ministry of Justice, the Commissioner Chu Gyu-ho, is going to tell us about the current status of Korean immigration management and the need for the qualified migration advisors. Commissioner Chu is very important in a sense that Korea is going through the transition from the homogeneous country to multicultural one, and I guess that the government as a whole is quite edgy about our changes, and I'm sure that they considered the head of the Korea Immigration Service should be very competent and important person, and that's how Commissioner Chu was appointed. Commissioner Chu joined the Foreign Service in 1975, and as a career diplomat, he served in Venezuela, Japan, Italy, and the United States. He got bachelor's degree in law and his Master of Arts in International Public Policy from Johns Hopkins. And it's my honor to present you Commissioner Chu. Thank you.
Good morning, dear guests. It's my great honor to be here today, and I learned a lot from my colleagues from UK, Canada, and Australia. Before commenting on certain points on those presentations, I'd like to introduce our system, our way of thinking. As you might know, we are all in a fierce but inevitable battle of getting global talents to enhance the national competitiveness. I'd like to introduce, you might be well aware of those cases, but I'd like to introduce Hong Kong's case, for example. They have been attracting the global talents from mainly China and other parts of the world by quality migrant admission scheme since 2006. We have been watching this scheme very carefully, and recently Japan as well is making an eye-opening policy to import about 10 million people in the next 50 years, and turning itself into a nation of immigrants according to the ruling party's LDP's interim report of July this year. This to cope with the low birth and rapid aging of the society. Now, my government, since the start of Myanmar government, we started to change our stance toward foreigners in a positive way, saying, let's say that from the regulation-oriented management to the opening and exchange-oriented ones. In other words, Korea will be implementing more proactive and open-minded policies to attract global talents in tune with the national target of the new government to join the circle of advanced countries and to enhance national competitiveness as well. We'll have to attract talents from domestic and global markets and systematically support them so that such talents will find the right job to do and right place to live in here. My ministry is also working hard to systematically support the efforts to attract quality workforce in the areas of technological innovation, high value-added industry growth, and global business management for the sustainable growth of this nation. I'd like to name a few cases for attracting global talents. The first one will be this one. As of September this year, we made it possible for the person and his or her spouse to be able to obtain the permanent residence visa in overseas Korean diplomatic missions before they enter into Korea. Until September this year, it was not possible. One has to live here in Korea for more than 5 years to apply for permanent residence visa, but it changed. The second one will be this one. In older days, if one wants to get an employment visa, he has to have his employer send the invitation letter and make a contract in advance. But nowadays, if one belongs to the category of so-called global talents, let's say a graduate of top 300 world-class universities, or a employee of top 500 world-class corporations, he or she simply can come to Korea first and engage in job-seeking activities, training or employment under the name of job-seeking visa without any contract. In the same bid to attract more global talents, we set up the Contact Korea Center with Korea Trade Promotion Corporation's overseas outlets. And we will make it possible for the applicants to obtain the visas via KOTRA all within 5 days by online under the name of the HUNET Korea system. This system is an online visa recommendation and screening system. I hope this will be practical one sometime next year. In addition to this, we are planning to introduce by the end of this year the point-based system, as Commissioner McCarthy already touched upon. We are planning to introduce the same one for residence permits and permanent residence permit in consideration of educational achievement, careers and incomes. We are also planning to develop diverse ways such as increasing the quota of government-sponsored international students. Now, turning to the presentations made by three of my colleagues, I'd like to express once again my deepest thanks to the three speakers today. And it seems to me that Australia, Canada, and the UK impressed me a lot for being able to successfully attract global talents by the qualified immigration agent or consultant system. If I'm to outline the characteristics of these three countries, I can say the UK system is the system in which the government is playing the leading role, while the Canadian system is a kind of private-oriented system, can I say, and the Australian system is half public and half private system. Please correct me if I'm wrong. I believe these systems are developed in reflection of unique situations and historical backgrounds of each country. If Korea is to adopt the certified immigrant agent system, we also need to make more of an in-depth research on the systems of those countries. In the case of Canada, as Mr. John Ryan touched, he touched on the certain loopholes and certain challenges. I agree, it was very informative to me because there should be certain resistance because of certain interest groups. And also, you talked about the ghost counseling, ghost agents. And I'd like to ask you how many cases were there in this ghost agents or ghost counseling? Because I sense that even though a country introduced the kind of good system for good public services, there are certain loopholes and misconducts made by agents. So I'd like to know more about the system or the challenges, like the ghost counseling, how many cases are there, now how severe it is, something like that. And also, in Australia's cases, I sense that certain difficulty because Mr. Konya told us about the need to set the principles high, to set the requirements very high in order to prevent some misconduct or some lack in professional services, I should say. So you talked about the dilemma you're facing, the characters and some, can I say, criminal record or medical record, something like that. In obtaining and in using these kind of information, we should be very careful. So even though we have this kind of difficulties, I think we need to develop more of our system and our system in the future. We don't have to be quite afraid of this symptom of, either in the form of ghost agents or in the form of misuse of information, but we have to develop the system in a more sophisticated way. In the case of UK, I should say you are working very well in a sense. You are very confident that you are controlling the situation in a quite stable way, I should say. I sense that you talked about the trade body of immigration advisors. Am I right that there are about 4,000 advisors in all, or how many are there?
There are 4,000 directly regulated individual advisors by the office, but there are other advisors who are regulated by the designated professional bodies like the Law Society.
I see.
But I have always had regulation of the Law Society in that area, so I indirectly regulate
So in contemplating the possibility of introducing our system, we should think of the certain conflicts of interest among interest groups. Though it is in the spatial stage, I sense a certain degree of conflicts of interest already. So we need to know more about the system, your challenges you're facing vis-a-vis other professional groups and vis-a-vis other advisors. So that's my comments, if I may, and we'd like to invite more comments from the guests. Thank you.
Hello, my name is June Lee. I'm the Chief of Mission for International Organization for Migration here in Korea. I thank you for three presenters, all your excellent presentation. I particularly appreciate Ms. McCarthy's point that countries who are considering introducing a system where they regulate migration advisors have to think about the reason of putting such a system. And you mentioned protecting migrants who are mostly vulnerable and have reason to leave their country to begin with. I just want to sort of extend that. And in fact, it is not just protecting the individual migrants' interests, but in fact, ultimately, it is to safeguard the integrity of immigration system of Korea, and that ultimately again benefit host countries. So everybody is happy with a well-functioning migration management system. And I have, in that regard, I have one question to Mr. Ryan. You mentioned your organization is self-regulating. It's different from UK's case. Is there any other way that your association is keeping, let's say, the system transparent and accountable? And the second question is, you brought up the case of the Korean truckers recently being their claims compensated. That's very good to hear that they're in the end compensated, but is there any other way that the perhaps Canadian government or your association try to even prevent such happening to happen? And in that regard, I also want to link that with the mention of Ms. McCarthy about the global network of migration advisors. It would be fantastic if such a network can be set up. But the migration advisors in all three countries have to work with, I suppose, the partners in the countries of origin. How do you try to make that link sort of work without falling into crack of, the case of abuse and whatnot? Thank you very much.
Thank you for your question. I think as a first premise, you have to work, having had the experience of building out a national regulator, you have to, first of all, work from the premise that you are building a system. It's not going to be a perfect system. It's one that's going to face challenges over time. There is no way when you start to build a system that you can foresee all the challenges and the problems that will be given, especially given the dynamic nature of the global human resource and human immigration systems that are out there. You do the best you can in national framework. You do it in the Canadian context. We've done it in cooperation with the government. In Canada, the Canadian Society of Immigration Consultants enforces and holds accountable its members, people who are certified members. The government of Canada, through its policing agencies, hold accountable those individuals who are working outside the scheme. Oh, well, I can hear myself, so hello. So I think the first premise I would say is that I agree with my colleague Suzanne, you have to build a system that works within your system, in other words, Korea's, something that's Korean at the start of, because you've got, you know, in our situation we have provincial, we have the Constitution, we have national powers, provincial powers, so one size does not fit all. With respect to the second question that you mentioned with respect to what is the government of Canada doing, it is actively enforcing to the extent that it can, but I think one thing we all share is we share a limitation of our national laws. So while the Canadian or the Australian or the UK or the Koreans may have the best system, who knows? The fact of the matter is all of us suffer from the same handicap, and that is we can only marginally address extending our laws beyond our own shores to protect the individuals who are coming from international locations. What it requires is we have to be innovative. And this is why I'm so happy that this conference is happening and that Korea is currently looking at it. Getting to your point about the global cooperation, we have to start thinking nationally but internationally. We have to start designing our regulatory systems to work together so that if somebody is abused in one jurisdiction, the perpetrators can be prosecuted in another. And that requires respect, it requires working together between regulators, and certainly that's what Australia, the UK, and Canada is starting to begin that dialogue. I've met with the Chinese, I've met with other countries who are either regulating in some form, and certainly we all face the common problems. With respect to, can we stop it at the source before it occurs? In a perfect world, yes. But I think we have a long way to go before we achieve that. Can we stop the abuse from starting in the first place? But we're certainly stepping in the right direction.
Is this on? Yes? Good. There were just one or two points I want to make. First of all, in respect to what Commissioner Chu said in his summary about the UK system with the government having a leading role. It is correct, and I think with the other systems, that in fact the Office of the Immigration Services Commissioner is a statutory body, that is, that it was created by legislation. But I would emphasize that my office is independent of government. If someone comes and gives me information, it is confidential to my office. It doesn't get sent to the Home Office or UK Border Agency unless that person gives me consent to give that information, or I must do so because law requires me to give the information up to another person, which is very rare. So I would like just to say that while I work with government, I'm accountable to the Home Secretary, I'm not part of Central Whitehall. I am a separate regulator, and I have my own requirements under statute. I also wanted to mention about the international system that I have a national jurisdiction, but the problem is international, and you have to find some way to square that circle, so to speak. And what we need to find is a way in which we can recognize that a CSIC advisor and a MARA advisor and an OISC advisor or a Korea advisor are in fact have the same minimum standards and can be mutually recognized. That's not the same as regulation. It is a recognition that they are passported into having the ability to give advice about certain issues. And we start with that by looking at exchanges of information, exchanges of intelligence as far as we're able, putting in standards of practice which create a baseline from which you can be assured of good immigration advice.
Thank you. Sorry to cut you off because we have a following session coming in. Thank you very much for coming, and I hope that this important forum is the beginning of mutually beneficial consortium of migration agent regulatory bodies. Thank you very much for coming again.
Could I just